So thanks, Ray, very much. And good afternoon, everyone. And for those of you on the West Coast, good morning. As Ray said, I'm Sue Carbon. I'm a circuit court judge from New Hampshire. And I'm delighted this afternoon to be participating in this webinar with Commander Mark Perkovich from Arizona. So you've got both coasts working here together. And our presentation this afternoon, as Ray said, is on civil protection orders from the inside out. A look at what courts and law enforcement can do to enhance their use and efficacy. Between Mark and I, we have about 60 years of experience in the field, and we hope to share some new ideas with you this afternoon, as well as reinforcing some very fundamental principles. I think we'd also like to thank the National Domestic Violence Fatality Review Initiative for hosting this webinar. Mark and I, and we're both going to use our first names during the session today, believe that domestic violence has only increased during this awful pandemic. And of course, domestic violence homicide, and as well the use of firearms. So I think the webinar is going to be particularly timely, and we both hope that you are all going to learn a great deal. As you know, when you registered for the session, we asked you to complete some questions, and we found out the number of years of experience in the field. And we were both quite happy to learn that there are so many who are quite new. In fact, we think about half of you have about up to 5 years of experience, and then the other half more obviously than that. So a good portion of you are very new to the field. And as well, we've got a very broad range of professions who are involved, judges and law enforcement personnel like Mark and me, but also advocates, attorneys, other court personnel, mental health providers, and so forth. As you're going to see this afternoon, doing domestic violence work is very much a collaborative endeavor. None of us can do it without the other, and Mark and I will hopefully show you that this afternoon throughout our session. We've got a lot of material to cover, so we're going to go ahead and get started. For any one of the topics that we're going to be covering, I think we could do an entire webinar. So we do invite your comments at the end. If there's something that you hear that you would like more training on, please let us know. That will be helpful for us. So I'm going to start out by reviewing the learning objectives that we've established for the webinar. The first is that we hope you are going to learn more about how protection orders can enhance victim and then also community safety. The safety is going to be the focus of our session today, and over again, you're going to hear about that. We'll talk a little bit about how we apply risk assessments to domestic violence cases, and then looking at some key strategies for issuing both clear and comprehensive orders. We'll talk about how we can incorporate victim autonomy into the decision-making process when they bring petitions to us and seek our help. And we're going to learn more about how courts and law enforcement can collaborate around the service of the protection orders, including, and in particular, in the surrender and the relinquishment of firearms and ammunition. And then finally, we're going to look at a better understanding of the heightened risks that are involved when firearms are involved in domestic violence cases. The material that we have today is going to be divided up into two sections. The first dealing with the issuance and the enforcement, the issuance and the service of protection orders. And the second will be focused on the enforcement of those protection orders. We're going to begin with some pretty basic information because we want to make sure everyone is grounded in the fundamental principles and to make sure that everybody is on the same page. So I'll start out by saying that understanding context is also critically important. We're not going to have a history lesson today on the topic of violence against women, but it's widely accepted that domestic violence is very much a gendered crime. There's a reason that we have an Office on Violence Against Women and that we have the Violence Against Women Act. We certainly recognize that there is domestic violence in relationships, there are same-sex relationships, and that there's violence against men committed by women and men. But the focus of this today in our session will be that protection orders themselves originated back in the 1970s on behalf of women who felt that the criminal justice system was not responding to their needs. And so primarily today, we're going to refer to the petitioners by she or her and the respondents by him or his, but recognizing that everybody can be a victim of abuse, and that will happen all the way through. So Mark, sorry, Ray, if you could move on to the next slide, please. So protection orders themselves, as I mentioned, are legislatively created tools. There's a protection order statute now in every state in the country. The first was adopted back in 1974, nearly 50 years ago. So they are now in all states and territories and many, many countries around the world. The focus of protection order legislation, again, is around safety for victims of violence and abuse. There's a provision under the Violence Against Women Act that was first passed in 1994, thanks in large part to our incoming president, who was then Senator Joe Biden, called the Full Faith and Credit Provision. And what this means is that a protection order issued in one jurisdiction is entitled to what we call full faith and credit, meaning full recognition in another jurisdiction. So if I issue an order in New Hampshire, that order can be enforced in Arizona, where Mark would be. One order issued in one jurisdiction, that victim can take that anywhere in the country. So think for a moment, a driver's license. You get a license in your own state, you can drive anywhere in the country with that. You don't need to get a new protection order. You don't need a new driver's license anywhere else you go. Or think of it in the analogy of a passport. Back in the days when we used to be able to travel, you could take your passport that was issued here and go anywhere in the world with that. Protection orders can be used in lots of different proceedings, but our focus today is going to be on civil protective orders in domestic violence cases. So the next slide, please. Let's talk for a moment about actually what a protection order is so that everybody's got that common understanding. A protection order is a tool for a victim to use to prevent or reduce future abuse. It's a voluntary process that is initiated by the victim herself, the petitioner. And it is a court order that can require either a restraint on somebody's behavior, so telling an individual, you cannot do something, you can't abuse this individual. Or it can also impose affirmative relief, such as you need to pay for the expense for the damage that you've caused, or you need to pay for child support. So both restraints and affirmative obligations. These are typically issued upon an emergency request. Legal language will be an ex parte request prior to the respondent being served, when notice is given to that individual. So a petitioner would come in, seek an emergency order because of some immediate risk of harm. And then this ex parte or emergency order is issued for a very short duration. Notice is then given to the respondent, and a final hearing is scheduled where that respondent or defendant, depending on the language in your own statute, has the opportunity to come and participate. The relief in that final order, if it is granted, can be much more expansive than in the temporary order. This is all of what we call a due process, this entire proceeding. So the next slide, please. The purposes of protection orders, again, as I mentioned before, are an alternative to the criminal justice system. They're designed, we're going to come back to this again, around safety. The idea is to restrain somebody's behavior so that we can keep the victim safe. And that may be restraining the defendant from having contact, causing harm, harassment, or stalking of the victim. But it also then will allow the victim access to her residence rather than going to a shelter, for example. So instead of removing the victim from the home and the children, we would remove the perpetrator from the home so that the victim and the children can remain in their residence. Protection orders can also provide for custody of children in those states that allow it. Not every state includes this in their statutes, but we'd encourage you to go back and revisit that. But if you do, it's an opportunity for the victim to have a short-term custody order. This can also include supervised visitation and or supervised exchanges of children. Protection orders can also provide for financial assistance. If the couple is renting an apartment, the respondent can pay for the rent, or child support or restitution, as we mentioned. But the intent here is to give greater control and autonomy for the victim. That's safety and autonomy. It's a victim-driven process. So Mark?
Thank you, Sue, and thank you for your introduction as well. Ray, if we can move on to the next slide. We did find that it was important to at least introduce some numbers for those of you in attendance. This really proved to be the framework. So while some of these may be familiar, I think they're worth mentioning, especially amidst the pandemic, where we know long-term studies will start to really compare and contrast where our numbers generally have been nationally. Most notably, 1 in 4 women and 1 in 7 men are victims of intimate partner violence within their lifetime. The other notable accounts here are about 10 million women and men are abused each year by their intimate partners. I think this is a number that will stand to grow. And most notably and horrifically, 3 women are killed by their intimate partners per day. And the most important bullet here on the slide is the very last one and serves purpose for us today, and that many had protection orders that were in effect at the time of incident. Ray, if we can move to the next slide. Generally speaking, with regards to protection order data, about 1.5 million victim survivors seek protection orders each year. And it's between 1/3 and 3/4 that report the protective order actually serves its purpose and ends the violence that might have been present for the cause of them seeking that order in the first place. And many choose, and these are petitioners, choose not to return for any type of final hearing because fortunately that immediate problem is resolved. Next slide. So in the latter part of the presentation, we're going to transition into the discussion of firearms. And this was one of those topics that Sue had mentioned early that we could probably spend a week-long webinar on discussing this issue. But just to give you kind of a sampling, these actually originated from our website. So if you're interested in further stats regarding your individual state, feel free to visit ndvfri.org. And we can provide you additional information at the end of today's webinar. But you can see by comparison and contrast, Sue obviously being in New Hampshire, their DV homicides by use of firearm at about 50%. We're in contrast, Arizona, who has very liberal gun laws, is about 70 to 75%. In speaking to our executive director, Neil Websdale, who's been in the field for, gosh, I think almost 50 years, he said on average, researchers use the number between 60 and 70% of DV homicides that are caused at the hand of individuals by use of firearms. And next slide, please.
So years ago, the National Council of Juvenile and Family Court Judges recognized that judges and law enforcement and others really needed guidance on how we could better enforce protection orders. And once we got into doing this work, we recognized that we can't enforce protection orders unless the orders have been issued and served appropriately. So we took a major step back and started working on this guide that originally was published back in 2005, called the Burgundy Book. It was a guide to help all of the various professions that work together around domestic violence better serve and issue and then enforce these protection orders. Ray, if you can go to the next slide, please. We developed this guide that, as I say, was first called the Burgundy Book, but then shortly thereafter, when the Violence Against Women Act was amended and our own practices got better and we started learning more, we updated this guide, and now it's the protection order guide that you saw in the previous slide. We have literally trained thousands upon thousands of people all over the country in every profession, and we've trained and disseminated these guides internationally. We've done lots of implementation training, but I would also advise you that there's lots and lots of technical assistance available. So if you want folks to come into your state and help you with training on this, there's lots of technical assistance you can call upon, so please reach out to the council. Can you go to the next slide, please? The protection order guide, I want to stress, is a multidisciplinary guide. It was developed by and for judges, clerks, prosecutors, law enforcement, civil attorneys, advocates, and others to help them better serve victims through the use of protection orders. We wanted to focus first on the issuance and then service and then following up with enforcement of protection orders so they could be done more effectively, so that in turn, we could enhance the safety and protection for victims of abuse and their children. All of this work is grounded in best practices. This is really more about practice and how we implement practices than it is around the law. And so some of the common practices and values that we found throughout all of the disciplines were developed and focused on first in this guide. And that's what we call our common ground, our common set of core beliefs and values that transcend any individual profession. So a value that would be important to me as a judge would be important to Mark as a law enforcement officer. And Ray, if you go to the next slide, please. Okay, there are basically 6 major core values that support the work around protection orders. And the first, again, I'm going to come back, is safety for both the victim, and if we can keep the victim safe, we can keep the community safe. These universal values also include victim autonomy. It's a victim-driven process that is designed to meet what her needs may be, not what the state thinks her needs should be, or the state telling her what she needs to be doing. A third core value is accessibility, and this is a multifaceted core value. One part of accessibility is that it's easy access. You know where to go to get a protection order. You know where the courthouse is. When you get to the courthouse, the forms and the information that you're provided is easy to understand. There's no cost involved, so you don't need to worry about whether you've got money to be able to afford this. There are no language barriers involved. You've got somebody to interpret for you if you need it, but the forms are easy to read. They are in plain English, they're not in legalese. And as well, that there are no cultural barriers to accessing these. Ideally, the gold standard would be that these orders are available 24/7. Lots of states provide this, not all, but the idea would be, if possible, you would have them available because violence obviously can happen at any point in time during the day. A fifth core value is reliability and collaboration. It's important that the process is consistent, so no matter what judge or law enforcement officer you may interact with, you're going to get the same good response. We want to make sure that in terms of competence, that everybody who responds in the system is knowledgeable, but importantly, not that they just know what to do, that they care about what they're doing and they're committed to serving the public well. And finally, that the system players, those of us who are in part of the system, represent the community of people that we serve, and that we are always reaching out to underserved populations to make sure that what we've designed that we think is a good system is accessible for everybody within the community. We want to make sure that we are all working together and collaborating so that we don't have gaps between our system. It doesn't do any good if Mark as a law enforcement officer is doing everything he needs to do, and then we get over to the court and we're dropping the ball. We want to make sure all of the systems are linked and working together. So, next slide, please.
And really what Sue has essentially set the foundation for is another theme that we hope comes through in today's presentation strongly. And that's really the coordinated community response, really just that concept. And one of the areas that the Family Violence Center would love to see be incorporated into the petitioning for civil protective orders would be incorporating the use of risk assessment tools. Currently in Arizona, a lot of our agencies are adopting and implementing the use of the appraise. Ray mentioned that in the opening. That's the Arizona Intimate Partner Risk Assessment Instrument System. And this was truly a community-informed risk assessment. It was piloted here in Arizona, up in Prescott, if you're familiar with Prescott, beautiful country. It incorporated police, prosecution, defense, judges, victim advocates, and it was a true demonstration of that CCR. And we'll talk more about CCR later. But when you're looking at employing the risk assessment, how do we know when that danger exists? Much research done by Dr. Jackie Campbell and Dr. Jill Messing, also with our Watts College here at Arizona State University, have been able to show through research things like the following factors listed here, showing that ultimate control of their partner and behavior that shows fear of losing that control, more importantly. And this is probably the key of this slide, this number 2 bullet, because we know that when perpetrators are at their most dangerous, it's when they're actually in fear of losing that control. And that certainly makes that behavior more dangerous in those interactions. And Ray, if you can, next slide. And these are the factors that we're talking about with that increase of overall dangerousness. I mentioned we'll be obviously discussing the presence of firearms, the dispossession gap in future slides. We know that alcohol and drug abuse can, of course, increase dangerousness. Past criminal history of violence is certainly a good indicator. What's the expression? It's the past behavior is predictor of future performance. What's predictable is preventable. And that's the construct of really where we're at today. And then contrary, the lack of accountability for the behavior in the past. And we're going to talk about barriers in why victim survivors don't look to secure a petition order and how this might have affected their decision, that lack of accountability. Next slide. And so when we talk about goals and benefits of risk assessments, just in the law enforcement arena, I think we have about 8, maybe 9% of today's attendance. So I'm going to speak directly to law enforcement here. This helps us understand the victim's true needs. And what I mean by that is typically law enforcement officers across the country are tasked with the same thing day to day. And that's responding to those calls for service that tend to stack up in the dispatch center. And oftentimes it's referred to as I go call to call to call. And how much time can I actually spend on one call when I know that there's other priority needs of the community out there? And so this dialogue with the risk assessment, the questions that are incorporated, the questions that are answered voluntarily by the victim when posed, giving them some element and sense of control back, really adds to the understanding of law enforcement far beyond the typical questions that we typically ask. And that's the who, what, where, how, why, and when. And that's all incorporated in our police report, and we hope that that reaches successful prosecution. But I think this changes that lens that law enforcement can look at these situations, oftentimes repetitive in nature, oftentimes may even be viewed as an inconvenience, going back to the same address, dealing with the same parties again. Most importantly, it conveys to the victim that there's an unbiased assessment of potential risk in their relationship. It's not law enforcement pointing out the obvious or repeating things that they may have heard already from friends and family. And most importantly, assists victim. Sue mentioned time and again that this is all built on the concept of safety. This truly assists the victim with safety planning. With the appraised tool, regardless of whether an arrest is made or not, a referral by law enforcement to social services and victim advocates can be made for that single purpose of breaking that cycle. And then, of course, it strengthens our communication, collaboration, and coordination between victims, law enforcement, victim advocates, and the courts. And when I mention courts, it's all parties involved. The appraised tool that we're using here in Arizona, I don't know if I mentioned prior, this was vetted through our Arizona Supreme Court. It is actually endorsed and recommended by that court system. This has certainly lent additional credibility to the use of risk assessment in our criminal justice system. And next slide.
Great. So the question here then, we've heard about law enforcement. Why should courts use risk assessment information? And I want to dovetail off something Mark just mentioned a moment ago, that these can be important for courts. And they can be important even when we are receiving a call in the middle of the night from a law enforcement officer, at least the way our protection order works in New Hampshire. If there's a victim in the middle of the night who needs an ex parte emergency order, the law enforcement officer will respond and make the call to the judge asking for an order. And they will tell us if they have screened the case as a high-risk case, which tells us this is really critically important. We need to pay attention. You need to wake up at 2 o'clock in the morning and really focus on what's going on so that you are listening well to the facts of the case and then applying the law. But especially around risk assessments, beyond that, when we're in a courtroom context, these can provide us with important contextual information so that when we're issuing orders or making decisions, we've got some good information. I want to stress that a risk assessment tool is not an evidentiary tool. So for the lawyers and judges out there, don't think that you can admit this into evidence and it's going to give you a scientific telltale sign that if you have X, you're going to do Y. But it will give you good background information to think about when you're making the decisions that you need to be making. We're pretty accustomed to using risk assessments when we're in criminal cases, if we're making decisions about release from jail or conditions of bail. or if we need to make referrals to advocates for the high-risk victims that Mark mentioned a moment ago. But when we're in protection order cases as well, this will help us understand the scope of protection that we should make sure we're going to build in to an order. It also helps us plan for the actual hearing themselves. When we've got somebody in the courtroom, might we need additional security to provide protection for the victim? It also helps us know if we should be referring the victim to an advocate or making certain that an advocate in the courthouse is brought into the courtroom to help that victim. And it also helps us to focus, especially in cases where it's discretionary for you, to decide whether we should be ordering surrender of firearms and ammunition at the time of an emergency order. So next slide, please.
And so moving forward, what we like to do is just spend a little bit of time on those tools that are both affiliated with courts as well as law enforcement for the issuance. And most notably, our tools can be both process-oriented as well as substantive. And so if we take a look at the next slide, this is an example that recently came out in Arizona. You can see that this project was launched January 1st of 2020. And really, this is probably one of the best examples that I can give you in today's webinar from Arizona, where, again, it was built out of a coordinated community response. This has become known as AZ Point. It's the Arizona Protective Order Initiation and Notification Tool. We basically arrived at the system after a series of changes in law, court rules, and the overall process to facilitate the easier creation, petitioning, and service of those orders of protection or civil protective orders. And so what we're looking at here is the ability for a petitioner to actually, with safety in mind, really traverse this process without ever having to make face-to-face or even subject themselves to going to court. And the reason that's important, I'll share, Ray mentioned in the opening that I've been doing some work in our rural communities with securing pro bono representation for victim survivors in domestic violence cases. We had a young woman who went into the court down in Santa Cruz County, which is a border community, if you're familiar. And she hadn't even made it into the courtroom to present the petition to be heard by the judge. And she was getting phone calls from her intimate partner questioning why she was there at the courthouse. And the fact remains, small community, one of the relatives of the respondent in this case identified and recognized who the petitioner was and immediately started calling them to really warn them that, hey, they're down here at court. I don't know what they're doing. I think they might be seeking a petition order or a civil order for protection. And so this system is set up to hopefully create better collaboration between the parties that are involved. So the three facets that are listed here, the goal is answering questions to create the petition. This is a process that's all electronic. Once a petitioner registers within the AZ Point system, they actually have up to 90 days to complete that petition. And most of them are obviously completed in relative close proximity to when they start. And then from that point, actually filing the petition with the court, that results in the review. And then within a 72-hour period, there's conveyance for service. And we'll talk in a future slide about the level of importance that this time period from, transfer from the court to law enforcement and why that's critical. And then the other key part of this program is that if a victim survivor doesn't feel safe in the community that they were residing, they can actually go and have their protective order heard in any court within the state of Arizona. And then when it comes time to service, the recipe is found parenthetically there with the court plus the zip code of where the respondent lives transfers to that particular service agency. And hopefully this has created that additional efficiency in not only the hearing of the order, the conveyance of the order, and then obviously the service of the order. And so that website at the bottom, you don't have to worry if you visit that website. It's not going to force you into, being identified. You can actually visit that, climb around that system. I encourage you to do that to see why it was built. And there's some additional information there for your reference. And if we can move to the next slide.
Really innovative. That's wonderful to see that. There are a number of court tools that we have for the issuance of civil protection orders. And some of the court tools are both process-oriented, such as Mark was talking about, and then also substantive as well. But having good information is foundational to everything we do in the protection order process. There's a colloquialism, good facts make good law. By the same token, it's garbage in, garbage out. If we don't get good information, we're not going to be able to properly serve the victims. We want to make sure that victims know all of their rights. They know what they can ask for. They have access to brochures, to advocates, to videos. In New Hampshire, for example, and several other states now have videos that people can come and watch to learn how to apply and to learn what they need to provide to the court so that we can issue an order for them, and also have access to any other bits of information and resources within the community. The forms themselves need to be clear, the petitions need to be clear, and the orders as well. If they're not clear, people won't understand them, they won't complete them fully, and then potentially we're not serving victims if we're not giving them all to which they are legally entitled. Providing interpreters is something that is also required under federal law for courts to do, and I think everyone else is doing this as well, but critically important that we make sure that we are meeting victims where they are and providing them with what they need. I would also encourage you in further collaboration to work with your U.S. Attorney's Office when you're creating your court forms to make sure that they actually can be enforced in federal court if necessary. Can we go to the next slide? In terms of substantive relief that courts have to offer, economic relief is absolutely vital to a victim's ability to extricate herself from an abusive relationship. I can't stress this enough. When you look at the data, 75% of victims report some kind of economic domination. It's a huge percentage of victims. And we also know that domestic violence is now a major cause of homelessness for so many people. So one of the tools of relief we talked about a moment ago is economic. So providing housing assistance in terms of rent, if the parties are renting, or if they own a home, that the mortgage will be paid. If necessary, if the victim is really unsafe, then relocating her, oftentimes through your Attorney General's office. Even things like ordering that the defendant surrender all of the keys to the apartment can be useful. There are other forms of financial assistance for car payments or utilities, or awarding those to the victim. Restitution can include medical bills, loss of income if they miss work as a result of the abuse. We've had victims have all of their clothing shredded. They've had to go buy new clothes just to go to work. That's an appropriate area for restitution. Paying for attorney's fees is authorized under our statute. I think it is in many jurisdictions as well. That's a tool you can use. But it's critical to remember that appropriate economic relief can truly make or break a victim's ability to separate from an abuser. And stressing again, you absolutely cannot ignore poverty if you're going to reduce violence. The two are very much connected together. You've got to pay attention to the economic relief if you're going to give a victim what she needs. The next slide, please. By the same token, children are a critical element. There are many, many times when victims will say, or will find out that they won't leave because of the children, or they finally decide to leave because of the children. So the kids themselves may be the drawing card about whether they will or won't leave a relationship. It's possible that they will stay in an abusive relationship because they're afraid that if they do leave, they won't be able to support the kids. So that need for economic support. Or they're afraid the judge won't grant custody if they do leave. Or if they leave, they're not actually going to see what might happen to the kids, and they might be safer if they stayed. So it can work either way here. So having the opportunity to make provision for ordering child custody and support and supervised visitation or exchange can be important substantive tools when you're issuing protective orders. So next slide, please.
And so now we're going to transition a little bit into the tools for improving the issuance of our civil protective orders. And before we move on, I just noticed that somebody did post a question. We're about a third of the way through today's presentation. I do encourage you, if we've stimulated some questions, thoughts, ideas, please share that, and we'll do our best to address that at the very end of today's presentation. So when we consider some tools for improving the issuance of CPOs or civil protective orders, we want to kind of hover around two different areas, and that's entry into the state and national registries that we know that are in existence, and then the actual service of the orders. I mentioned in that previous slide that there's a 72-hour period still where the court has to transmit that over to law enforcement for service. Notably today, our attendees, about 85% of today's attendees reported that civil protection orders are served by their local law enforcement officers. So just to keep that in mind as we move forward. And next slide, please. And so considerations for the service of protective orders, I've kind of broken this down into really two parts. There's our pre-service considerations, and then there should be also our post-service considerations. So for law enforcement folks that are in the room, or any civil process servers or agencies that are familiar with who actually serve your orders, these obviously have to be treated with the utmost of timeliness, as well as respect for the current situation that's resulted in the issuance. These pre-service considerations on behalf of law enforcement should, of course, consider the timeliness of the delivery of the order to that serving agency, and then also the time that it takes to push that out into the field for actual service. My home agency, we had a system set up where it was actually assigned a individual incident number that just added to further tracking. It was then assigned a priority for service for our patrol or specialized units within our DV investigative unit to go out and actually serve. And that was more of an internal accountability. Other things that we recommend for pre-service considerations: know what you're walking into. Does our respondent have a criminal history? Did it include violence? Does it include prior firearm ownership or current firearm ownership? Any risk assessment results. We talked about the ability that risk assessment tools can be used in the variety of circumstances. This is certainly one of those. And then taking the time to interview the associated parties. This can also include any information that they're familiar with firearm ownership, what kinds of firearms, locations, have they been transferred to third parties already? And then post-service considerations. It's always a good practice to document the service attempts if you're unsuccessful. Excellent information to be gleaned from the respondent's behavior during service. And then the time needed for removal. Time and time again, we often see, the orders are being registered within law enforcement agencies. They get sent out more or less at the time that's more, I'll say, convenient for those pending calls for service. But considering, hey, if I'm going to a house at dinner time and the respondent's there, and they're in the process, this is a very jarring effect for not only our petitioner, but certainly our respondent if they're unaware that this is on its way, and then any children that might be in the home. And then the most important post consideration that we're going to talk about here in the ensuing slides is firearm seizure and impound, and what to do and have that plan of what needs to be done at the time of service. And next slide, please. And so we're going to talk now about the role of firearms in civil protection orders. And we'll do that by starting in the next slide. And so we had brought up in that prior slide, I had talked about the various states and the percentage that firearms are present in domestic violence or intimate partner homicide cases. The cautionary tale here is the very last bullet, actually, and it's a majority of abusers with access to firearms do not kill their victims. And so even though that's the case, we still look at what can be learned from tools like a risk assessment tool in preventing those issues. So that's very much a preventive issue. But considering the abuser's access to firearms is really the single greatest risk factor for intimate partner homicide. I mentioned already gun laws here in Arizona. You can now carry concealed here in Arizona legally without permit or license. And we know that nearly 1/3 of all women murdered in the United States in 1999 were killed by current or former intimate partners. And guns were obviously used in almost 2/3 of those cases. And so when we consider comparing to homes without guns, presence of firearms creates the following. There's an 8-fold increased risk of homicide when the offender is an intimate partner, and then a 20-fold increased risk of homicide when there's a prior history of violence. And so those are kind of staggering, but we have the source of those if you're interested in further follow-up. And if we can move to the next slide, Ray. And so we want to break down, I guess there's obviously governing law, both at the federal level as well as the state level. This slide obviously covers what are federal statutes, our US codes that govern that, prohibiting possession of firearm while subject to a protective order, prohibiting the transfer and return of firearms to anyone who's subject of a protection order. I mentioned our gun laws here in Arizona. Typically when we talk about national registries, and I think we talk about this in an upcoming slide, the resources that are available for gun store owners or those with federal firearm licenses, as well as pawn shops and other retailers. But one of the areas that we still fall short is Arizona's renowned for having gun shows. In fact, you can attend a gun show on almost any given weekend, and it's set up more in a cash and carry fashion. So just to round out our federal codes here, there obviously is a statute addressing the lifetime ban on possession of firearms if convicted of a qualifying misdemeanor crime of domestic violence. And then there's a prohibition of the transfer and return to someone convicted of that QMCDV. Next slide. And so these are just recent stats that we found coming out of the Justice Department. In this last fiscal year, they had 500 plus DV related firearms cases that were charged out. With a breakdown on that second bullet, you can see which statute was actually used in enforcement. The in possession, the DV felon in possession, obviously the highest with 337. And then clearly the 142 with possession by the prohibited person. And that again was our qualified misdemeanor conviction. And next slide.
So focusing for a moment on the protection orders, the ones that are covered under the Gun Control Act, these are the domestic violence civil protection orders where there's a restriction on possession and purchase of firearms. So domestic violence civil protection orders issued after a hearing where the respondent had notice and an opportunity to participate are those which are banned under the Gun Control Act. But there needs to be a firearm prohibition if the respondent is in one of these relationships with the victim. If they are a current or former spouse of the victim, if they've had a child with the victim, or if they've lived together. Now, a dating relationship where there's been no cohabitation does not qualify under the Gun Control Act, but if they have cohabited, then it does. But importantly, what this means is that under federal law, temporary orders don't qualify. So in other words, there needs to be all of the due process requirements, the notice, the opportunity, and an opportunity for a hearing so that the respondent can have his voice heard at the time of a hearing, not just the petitioner's concern. And we're going to come back to what this means in a moment, but if we could go to the next slide, please.
All right, so we have our first polling question. I'm going to go ahead and launch that now. So again, this polling question should pop up on your screen here. If you could submit for those 2 polling questions and then go ahead and hit submit, we can have our participants take a look at that. So we'll give it about 30 to 45 seconds there. I appreciate it. I see the incoming responses now, so I really do appreciate it. This is great to see that you guys are submitting your responses. We'll give it about another 10 seconds, and then we'll have our presenters go ahead and speak about those. All right, we do appreciate those responses. I'm going to go ahead and end the poll now. And then go ahead and share these results so we can see that here. So Judge Susan Carbon and Mark Perkovich can see these results. As you know, that it looks like for our first question for the temporary orders, It is discretionary under the order to surrender. About 49% of our participants said that. And then for the second question, for final orders, it says it's mandatory to orders to surrender is about 48%.
So this is really interesting. If you can leave that poll up there for just a second, Ray. We've shifted now from what the federal law says, where it's under temporary orders for federal law, it's discretionary. There is no law, basically. But when you have a final order under federal law, you must relinquish. But that's federal law, and we need to look at what is provided for under your own state law as well. So here, as Ray just pointed out, a lot of jurisdictions, almost 20%, don't have any legislation on that. You're not required to, but it's just an observation that you don't. And then another 50% say that it's discretionary. And I think there's, obviously that's the prevailing view, but there are a number of jurisdictions, about a third here, that track or that go beyond what the federal law is by in fact providing more protection than what the federal law says. And I think this is indicative of the sense that if the whole purpose behind protection orders is to provide safety and you've got firearms, then you should be taking them at the time of a temporary order. Certainly they can be returned if the final order is not approved, but this reflects that ongoing concern about safety for the victims. What I think is interesting when you look at the final orders, looks like half make it mandatory, but still 40+% say that it's discretionary. So that's really an interesting observation. Mark, did you want to add anything on that before we go on?
No, that was the response that actually jumped out to me, still being discretionary in that final order. I'd love to learn more about that and what the reason behind that might be. But yeah, that was the popping percentage there.
Okay, great, thanks. Ray, could you go to the next slide, please?
Of course, I'm going to stop sharing now. Thank you for your participation, and then go ahead and go to the next slide.
Okay, so when we look at state laws on protection orders and firearms, as the last slide just noted, sometimes the state laws are consistent with federal law, and about 42 states have got legislation that's consistent with what we saw in your responses here. Some are silent, they completely leave discretion to the courts, and then others are more protective, as we saw in the slide. But importantly, federal law says that you can't possess or purchase firearms, but what the Federal Gun Control Act does not do is to contain any provision for the actual mechanics of relinquishing or surrendering firearms. That process is completely left to the states. So the next slide, please. So when we look at how it is that we actually mechanically, physically get those firearms, we've got strategies for both courts and we have strategies for law enforcement. From the court standpoint, here's a couple good tools to use. You can always ask the victim about the presence of firearms at the time that she applies for the protective order, even if she doesn't make a reference to it in the application. So there may be an allegation of any number of different things, but silent on firearms. But it's okay to go ahead and ask, because if there are indeed firearms and they've been used in the past, perhaps not the most recent incident, that might give a judge reason to order surrender. You should always be using whatever appropriate authority you have, and even in jurisdictions where your legislation is silent or it's discretionary, almost every statute has got what we call the catch-all provision, saying that you can take whatever steps are necessary to prevent future abuse, including but not limited to X. And that X could be ordering surrender of firearms. When you move to the final hearing, and if firearms were ordered to be surrendered, ask the defendant if he in fact surrendered them. Build accountability into your system. Federal law, the Violence Against Women Act, now also requires us to have a colloquy on the record with defendants to explain to them that they may not have firearms if a protective order is issued, a final order, and inform them about what the risks are in terms of the financial penalties and the risks of incarceration if they're convicted of violating that protective order. And that's a requirement, because nobody, judges, attorneys, nobody wants to have a gotcha moment for a defendant. We don't want to set them up and say, well, you should have known this, when they're not going to know. It's up to us to convey that when we're in a hearing. So making sure that we are clear about what the law is and that we inform people about what the law is. So next slide, please.
And so these are the strategies for law enforcement. When we consider, well, we saw from our polling question, the variety of, I guess, orders that could exist with regards to firearms. I think first and foremost, for our law enforcement folks, actually reading and understanding what the order requires and if it orders that requirement of the relinquishment of firearms. But not just stopping with the discussion with the respondent about firearm in that third bullet there, although I think that's important, just as important as getting it on the record, as Sue mentioned in court, but inquiring this information from all parties, learning who owns the firearm or firearms. Are they currently in possession of the respondent? And this can be, again, asked of the petitioner in advance, as well as neighbors, other friends, family that might be providing intelligence or other information. And then most importantly, where are the firearms specifically and physically located? We've talked about obviously advising the respondent, informing them about what restrictions they might be under, as well as that duty to relinquish. Locally here, we make it a requirement of the serving agency to take possession of those firearms. There was from time to time some, I guess, back and forth with our local law enforcement folks that instead of kind of getting into taking possession of someone's firearms and kind of addressing that issue of right to bear arms, we would push them into the jurisdiction that the respondent might be moving to. But now it's more common that we actually have the serving agency take possession and obviously store those for that duration of that order. And then considering what to do about those third-party transfers. There were many times where we went out to serve an order and the respondent, we knew the respondent obviously was a firearm owner. And upon service, when questioned about their firearm possession, they admitted, they've been transferred. Well, who are they transferred to? Other family members. And so what do you think that might do for their, obviously, ability to regain possession of that firearm? There's nothing in our law that states that that can't be done, but at the time of possession, it's law enforcement's obligation to actually seize that item and impound it. And then what to do if the respondent refuses to relinquish. Sue, I think I read in your Burgundy book or your guidelines that it states clearly that law enforcement will secure a search warrant for the premise to actually go back and obviously, hopefully recover those firearms and handle that appropriately. So Sue, if you want to take us into the next part, I think that next slide is our transition.
Sure, absolutely. I'm just going to say that last slide that we were on, we could spend an hour talking about all of that: constructive possession, third party, you name it. My favorite line is hearing in court, I gave guns to my grandmother. It's just, you always wonder what they're doing with grandma and her guns. But we're going to shift a little bit now. We've spent the first block of time talking about the purposes and the goals of protection orders and how to issue clear orders, comprehensive orders, the importance of working with victim survivors and collaborating around service. But we're going to move on now into the topic of enforcing. So once we've issued good orders, how are we going to now enforce them? So next slide, please, Ray. And the objectives that we have for this second session here, or the second part of our session here, is on how we can collaborate together on enforcing those protection orders once we've issued them. We're going to talk about some of the barriers to issuing protection orders and to making greater use of those protection orders. We'll talk a fair bit about trauma and how that impacts the victim's access to court, what happens when they get to court, and the importance of us being trauma informed. We're going to identify some of the principles of procedural justice and how they can enhance litigant satisfaction. And then finally, focus on some of the strategies that we have to promote greater safety, accessibility, and accountability within the system. Because if we are not accountable to ourselves and to one another and not accountable to the victims, then what really good have we done? So I think we're up for another polling question, right?
That is correct. So we do have another polling question. We're going to do this one a little bit faster, if that's okay. We are cognizant of our time, so I'm going to go ahead and launch that. It is asking about the biggest barriers in securing firearms. I did want to make a mention that in our comments that we had a unique perspective on this. So one of the participants stated that our clients say that he can just go to the flea market and get a new one, and is specifically talking about the firearms when they are, if they are removed. And then also stated that never in my 15 years I have seen such a search warrant pursued in order to secure a defendant's firearm.
So do you want me to respond to the search warrant issue for a second while they're completing
Yeah,
the question? Okay.
I think that's a great idea, Sue.
Okay, so you can ask for a search warrant if you have probable cause. And when I mentioned that that's one of the things we could talk an hour about, you still need probable cause to get a search warrant. You can't just ask for one. And that may mean inquiring of the victim, do they actually have firearms? Do you know where they are? When was the last time you saw them? Can you identify them? Can you give me more specific information? Do you have reason to believe that they are still there, or to whom were they surrendered? So you do need specific concrete information. You can't just go on a fishing expedition in somebody's home in hopes that you're going to find a gun somewhere. So they do happen. They're authorized in our state. They're not frequently done, but they are certainly a possibility. Washington State, particularly in King County, is a national leader in this area, and we can give you some more resources on what they do around issuance of search warrants there too.
Thank you, Judge. I'm going to go ahead and close the poll, and we can take a look at the response. It looks like the majority of the response, 44%, says there's no way to keep track of these firearms. So that would be their biggest barrier there. Right behind that is going to be the lack of knowledge of the court to surrender, and followed by the lack of knowledge of law enforcement on how.
Okay.
So I'm sharing those results there. Do you want me to proceed? Or do you have any other comments, Sue?
Yeah, sure. Okay. And I think they've nailed it. Part of it is just the lack of knowledge on the part of judges to do. And so we're doing lots and lots of training for judges, but also because lots of states don't have any registration requirements. New Hampshire is among them. I would have no idea because there's no registration like there is in Massachusetts, for example, where they have to sign affidavits of every gun that they do purchase. So states are all over the map on that. It's a big, big challenge. Let's look at what some of the tools are to facilitate, though, the enforcement of protection orders for courts. Again, we're coming back to some really basic information that they can only be enforced if they're issued correctly. And this includes making sure that the orders are legible. I can't tell you how many times we get comments back from the registry saying, I could not read what the judge wrote. Or having an address where a respondent can be served. Making sure that the orders themselves are served in a timely manner. It does no good if we issue an order at 4:30 and it sits in the courthouse till the next day before we get it to law enforcement. We need to be transmitting them upon issuance. And then making sure that the form language comports with the requirements of the Full Faith and Credit Act. And by that, I would encourage you again to seek out some technical assistance if you want. Work with your ATF, your local ATF, and your local U.S. Attorney's Office as well. So next slide, please.
And so as we continue our discussion about those tools, the first obviously being the immediate entry into those state and federal databases, like NCIC, NICS. This is probably the most, I'll say more important one of the two, because this deals with the transactional aspect. So the National Instant Criminal Background Check System, which is what NICS stands for, is for those folks. Again, I mentioned this is actually exclusive to gun shop owners, pawn shops, and our retailers for that immediate background check to release that firearm upon or attempted purchase. On the prior side, though, it helps facilitate that immediate enforcement action too, if needed. And that's obviously checking the system to find out if who you're dealing with is the subject of a civil protective order, if firearms were actually part of their restriction, and then, of course, if they were in possession at the time. Next slide. And so when we consider some of the tools for law enforcement when enforcing our protection orders, most all the training that we do at the Family Violence Center, my counterpart is also a retired law enforcement Greg Gianjobi. Most of the law enforcement officers throughout the nation with at least 10 years of service have probably heard of the concept of nobility of policing. This was actually Dr. Stephen Covey's finding principle. Prior to his death, he was a huge supporter in law enforcement, and he came up with the concept of nobility of policing, remembering why we got started in law enforcement as a profession. And then obviously it builds upon that. You don't ever have that second chance to make that first impression. And so Greg Gianjobi, he was my counterpart and colleague at the FEC. Everything we train is trained in that construct of, if you're responding to a home with these needs, how would you want a law enforcement officer to respond to your family's home? How would you want them to deal with your mother, your father, your sister, or your brother if they're involved in these situations? And then the obvious, the enforcement of that protective order if proven to be valid. Also enforcing any custody provisions if present, although this isn't commonplace necessarily in these particular orders. They may be in your respective jurisdictions, so queuing in on what other aspects of the order might be at play, making that appropriate arrest for that violation. And this is a prime opportunity to conduct that risk assessment with the victim's voluntary participation. One of the areas of the risk assessment tool that was used here in Arizona that was required and mandated by our court was that the victim is made fully aware that their responses are voluntary, that they do not have to participate. We don't call it a refusal, we call it a declination. And then the other aspect is that it is potentially discoverable information. And then obviously making the proper referral to our community resources and our victim advocates. And next slide.
So we're going to talk a little bit at this point about what we call the dispossession gap. As we noted up above, the mechanics of the surrender or the relinquishment of firearms are left entirely up to the states. So federal law prohibits the possession, but then how do we enforce that federal law? Excuse me. So many of the states, as you showed through your own participation in the polling question, track federal legislation, but others also provide specifically for surrender and relinquishment after a temporary order has been issued. But even then, states, and this last bullet here, states vary markedly on implementation. There are many differences in the amount and the specificity of direction that is given to courts and to respondents and to law enforcement on how we actually mechanically acquire the firearms. So we've got law that says you can't have them, but then what? How do we get them? So next slide, please. So we have issues both for courts and for law enforcement. And for the courts themselves, in response to the question that somebody had about search warrants, it's helpful if you can identify and obtain as much identifying information about firearms as possible. Earlier on, we said having information is absolutely foundational. Same holds true on information about the firearms themselves, including information on petitions that victims will complete when they ask for a protective order, including the description of the firearms, the number of them, where they located, and any other identifying information that they might have. Now, if you're like me, I think I've been to a firing range once with Russian police officers, and that's the only time I've ever held a gun. I couldn't tell the difference between a long gun and a handgun, except one's long and one's short. So there is a guide that BW, the Battered Women's Justice Project, actually created to help victims provide identifying information about what the guns are. Because most people, unless you have reason to use guns or they're a hobby or whatever, may have no idea, like me, about a difference between a Saturday Night Special and a Colt 45. So if you can look at something and provide information, that's going to help the law enforcement officer, and in fact, may end up helping get a search warrant if you need it. So including that kind of specific information on the petition and then in the court order will be helpful. And then it can also assist judges in notifying respondents about what the prohibitions are, the dispossession requirements, and about what possible violations may exist. It's also, again, important for judges to have this colloquy after a final order is being issued to instruct them about the fact that they cannot continue to purchase and have those firearms in their possession. So next slide, please.
And so on the other side, issues that law enforcement may contend with, and issues specifically regarding the respondent, is that educational process. This may be very new to our respondent, much like it might be a new process to our petitioners. So being very clear in whom those firearms are supposed to be relinquished. Is it to me as the law enforcement here today? Is it to the FFL? Is it to a third party? Being very specific with what that time frame is, if there's an allowance for any time for voluntary surrender, or is it immediate? And then what type of proof of surrender? In our home agency, we would oftentimes seize the firearm under the premise of a safe keep or safekeeping. They would be provided a property receipt, they being the respondent. And then what other further obligations might the respondent be under to stay within the confines of that civil protective order? Is there an affidavit that needs to be filed with the court either on behalf of law enforcement or on behalf of the respondent? I think Sue's going to cover compliance hearings and the concept of compliance hearings in a future slide, and this would be one of those particular issues. Next slide. And so additional issues for law enforcement. Ideally, you'd like to obtain any type of firearms in their possession upon service. The colloquy with the respondents themselves or the interview, like Sue's mentioned, in the courtroom is just as important as it is out on the streets. The time from when the order was issued to the time that the respondent is being contacted and served could have provided the opportunity for them to secure a weapon or procure a weapon in that time frame when they may not have been in possession prior. So that interaction between law enforcement and respondents is very important. And then the verification that the weapons that are ordered to be surrendered are actually in fact surrendered, that it's not a, you know, we're again, I think similar to our friends that are in attendance today from Texas, we're a multiple gun state. You know, it's not just where there's one, there's many more. We kind of run with that assumption. If there's any issues concerning storage, space and fees, that might be the respondent's responsibility. Search warrants we've kind of covered already. And then what to do, in fact, if you've encountered the violation. I know that sometimes this became like a secondary issue for law enforcement at the time that a CPO might have been violated. The quick obvious is we have a violation that we can enforce of the order itself, but are we enforcing all aspects of that order? Equally important. Next slide.
So in a perfect world, everybody would follow the court orders, but we don't have a perfect world. And one of the most widely accepted ways of building accountability into the system is to have the compliance review hearings that Mark alluded to a moment ago. These are tools of accountability for us to ensure that our orders are being followed. The intent of these is to take the burden off of the victim so that she's not responsible for having the order enforced, but we ourselves are taking the affirmative step of saying we want to make sure that our orders are being honored. So we may have compliance on any number of different issues. The firearms surrender that Mark mentioned a moment ago is one great example. In some jurisdictions, they will, upon service, require the defendant to file a return with the court saying, I have surrendered, and it's an affidavit, all of my firearms. At that point, the compliance review hearing could be canceled if we have proof that they've complied with that order. But compliance review hearings can be used to ensure that child support is being paid, or that respondents are attending veteran intervention programs if those have been ordered. But it's just a way to ensure and follow up to make sure that what we've ordered, all intended to provide safety for the victim, is being followed. And there are lots of different ways these can be handled, either scheduled automatically in every case, or more often requested by one of the parties or law enforcement or prosecution to schedule if it appears that we've got an issue where compliance is not being followed, or building in a system where you can have affidavits filed in lieu of actual compliance hearings, given the fact that some judges are resistant to putting more on their dockets as well. So next slide, please.
And so the topic of firearms with CPOs are obviously another one of our coordinated community response items. These are the areas that obviously firearms can touch and affect. Law enforcement obviously being the primary, but victim services as well. The victim autonomy behind, Sue mentioned what questions are being asked of that petitioner or that victim survivor at the time they're attempting to secure that protective order. What are they telling the court about firearms? What are they telling the court about their belief of further or additional risk? And even with prosecution, looking at this from the perspective of, was the weapon seized at the scene of an arrest or during a violation? And then making sure that it obviously isn't returned under any other laws, and being able to coordinate. So the three aspects obviously just on the slide alone demonstrate that it's not just that single aspect of our criminal justice system to ensure compliance with our firearms. Next slide.
Okay, so we spent a lot of time talking about the purposes and the goals and benefits of protection orders, but if protection orders are so good, why don't more victims have them? And why do so few victims of homicide have them at the time of their death? So with that, we want to look for just a moment at what it is that perhaps we're missing here. So, Mark?
So what we've encountered primarily with a lot of research has been, retaliation from the perpetrator obviously is huge. 65% reported fear of retaliation. We mentioned children or children in the home, fear of losing custody, or even fear that, the order itself won't end what they're actually facing. I think one thing that wasn't on the slide too is, the false belief that the certified or the civil protective order will protect them. Anytime I served an order to a victim survivor, the emphasis was placed on this is a tool, but at the end of the day, it's simply a piece of paper that will hopefully protect you within our court system, but it may not physically protect you here in your home or your workplace or your kid's school or anywhere else they might find them. And then conflicted feelings about defendants. The victim may want to stop the violence, but continue the relationship if it can be safe. Fear of removing children from their birth father. And then the big one that Sue spent some time on in the first half of the presentation, that fear of the loss of economic support that might be the result of the CPO being served on the respondent or the defendant. Next slide.
So the court itself can be a barrier. We as judges are pretty good at telling victims that they ought to be applying for orders or blaming them if they don't apply for orders. But I think we need to recognize really carefully that sometimes we're part of the problem. People will be very reluctant to come to court to disclose to a perfect stranger some really personal information about what's happened to them. It's pretty tough to tell even a friend, for example, if you've been sexually assaulted. Imagine being in a courtroom in front of a lot of people, and maybe they're the seventh person you've had to tell this story to, and they're a perfect stranger to you. So there's a real struggle disclosing personal information in court. Oftentimes a sense of shame or fear of hostility that you're not going to be believed or you're going to be belittled for coming to court, asking somebody else for help. And sometimes having a lack of advocacy or a lack of legal assistance can be a real barrier. So next slide, please, Ray. I want to focus a little bit more about, though, our demeanor as being one of the biggest responses that can entrap women. Within the courtroom itself, it's an intimidating environment, especially if you've never been in a courthouse before. You've got a judge sitting up on a bench looking down at you, so that whole physical layout can be intimidating. And you may be perceived as receiving harsh treatment from somebody because they're scrutinizing what you did. And maybe they're second guessing you for what you did. And all of this may then contribute to the victim minimizing herself, what she did, or blaming herself. But it's worse when you have a judge blaming the victim or second guessing the victim for what she might have done. We hear a lot about second guessing, was she out drinking or drugging, or did she leave her children with somebody she shouldn't have left them with, or other things where we are actually judging the victim for choices that she made as opposed to applying the law, and if she's in need of protection, providing that. oftentimes as well, exhibiting greater concern for the perpetrator than the victim. So these are all some of the responses that judges convey that can make it even more difficult for women to seek assistance. If we go to the next slide, please. On the opposite side of this, I think it's oftentimes more important to focus on what it is that we can do to empower battered women to seek the safety to which they're entitled. And first and foremost, once again, is to prioritize their safety. Ask them about what they need. Ask about their fears. Ask about firearms. Make sure that when they come to the courthouse, actually getting inside the courthouse, in and around in a courtroom, and then leaving the courthouse, that they've got adequate security and that they're not going to be accosted by a defendant who found out that they're there and may try to attack them for being there. Make sure that the courthouse itself is hospitable, that they've got a place to wait privately, that they have access to interpreters and to advocates and to all the resources that they're going to need. And make sure that you're addressing the needs that they have, particularly around their children and the economic aspects of their abuse. And the next slide, please. And most importantly, I want to come back to what I believe to be the single most important factor that can empower women is a judge's demeanor. If you have eye contact, if you're patient, if you're respectful, if you inquire, if you're willing to actually listen and ask, and not simply rely upon the petition itself to figure out what the victim needs. There are many times a victim will complete a petition and something just doesn't sit right, and you need to meet with the victim and you say, why didn't you write this down the first time? Well, they may not have understood that they needed to because the information wasn't complete there for them, but they're too afraid to tell, or they may not understand. So taking the time, and it's only a few minutes of time that may be needed to truly inquire about what they need and do your job. You're often balancing the due process needs for all participants, but the victims are as important as anybody else. So take the victim seriously, treat her with respect, and understand the role that trauma can have in her life and how to apply the principles of trauma-informed courts. So next slide, please.
And so continuing with that idea and concept of trauma-informed care and response and approach, understanding how trauma can affect survivors in the courtroom as well as in the law enforcement context, we have to take note of what occurs with memory, what happens with verbal and nonverbal responses, things that we traditionally encounter that we would put in that norm category, the disassociation, lack of engagement, certainly triggers and reminders. If anyone has ever dealt with someone that's suffering from complex trauma, you have to remember that the incident that's like provided the basis for securing the civil protective order may not be the only traumatic event that this person or these people have dealt with throughout their lifetimes. Next slide. And so just really quick as we move forward, we want to be respectful of time, and we'll provide these slides to you as well if interested, and it'll be posted like Ray had said. Considering the traditional credibility versus the trauma responses that you might encounter, you know, the truthful attitude being composed, cooperative, direct, sincere, versus that disassociation behavior, that deadened or wooden effect and demeanor, or even hostile and defensive behavior that sometimes can be misinterpreted by all of us within the criminal justice system. Next slide. And again, continuing, you know, the verbal versus nonverbal responses and effects, those truthful verbal response, they answered me directly, they made eye contact, they recalled details, they were very specific with the sequential order of things happening or the chronology. And then with the trauma of X for verbal responses, they may have difficulty concentrating. They may jumble the order of events. They'll have gaps in memories. They may even get irritable when pressed for those specific issues. Patience here is patience and grace can't be expressed enough here. Next slide.
So why are these trauma-sensitive settings so important? And that's because survivors take this trauma. It is a part of them, and they take it wherever they go. When you look out in a courtroom, you're not necessarily going to know who's got a trauma history, but the important thing to remember is that we as judges or law enforcement, whoever it may be, will get better results from processes that are trauma sensitive. So, Ray?
And so how do we know that that trauma framework is helpful? We know that it can normalize those human responses to trauma. It shifts our conceptualization of those symptoms. We recognize that some of the symptoms that our petitioner and victim survivors might be projecting recognizes that impact on the practitioners, the organizations, and our systems. And it helps to counteract that abuser manipulation and control. In this next slide, this is something that it's a lot of words, believe me, Ray, if you can advance. This is really the 5 principles of trauma-informed care, if you're not familiar. Obviously, I won't spend time reading this, but the reason I like this, it represents those 5 principles, not only by definition, but it also gives you that example of what that principle looks like in practice. So for example, just that first one under safety, ensuring physical and emotional safety. How do we see that in practice? Your common areas of where you're meeting are welcoming. Are you at a family advocacy center? Are you at a law enforcement agency? Are you in their home? And providing that privacy aspect of where it is that you're actually talking. And next slide.
So let's talk for just a few moments before we close about how procedural justice can help trauma survivors improve their court experiences. The next slide. So procedural justice is really a simple concept, and in some respects it is so basic that we just look right beyond it without being cognizant of it in our daily work. But procedural justice or procedural fairness concerns the perceived fairness of treatment that people get while they're in a court setting or any other setting for that matter. But it's the procedures and the interpersonal treatment that they receive as opposed to what we call distributive justice or the outcome. So in other words, the process versus the substance, or another way to look at this is a question of how is it that I treated you versus did you get the order that you wanted? So next slide. The key principles of procedural justice are really simple and obvious, but they're really important to nail down. And if you think common courtesy, that's going to drive all of this. Everyone, whether you're the plaintiff or the defendant, the victim or the perpetrator, you are more likely to accept a court decision if these 4 things happen. And the first is that everybody has a chance to speak. Everybody has voice here. And that we listen when people are speaking and that we give them respect when they are speaking. We may not like what somebody does, but we respect them and we give them the opportunity to speak and for us to listen carefully to what they're saying. The third is the understanding of the process. Litigants deserve to understand what is happening. These are their cases. If they don't understand what's happening, then we are not doing our job. It is absolutely critical that they understand everything and that everybody, plaintiffs, defendants, all understand what the rules are for everybody involved. We need to make sure that we take time to explain. And if we explain, then the parties themselves will have more respect for us. We will show our respect for them. And there's a much greater likelihood that the orders that we issue, no matter what the orders are, will be followed. And finally, the fourth important element here is that the decisions are based on our neutrality, that we are not biased when we're presenting this information. Just to hit one more thing about the understanding of the process, make sure that the language that you use is understandable. I can't tell you how many times people will leave a courtroom and say, what happened? They should never leave a courtroom wondering what just happened to them. Just like you wouldn't want to leave a doctor's office not understanding what they told you, it's important that we all understand everything that's going on all the way. So the next slide, please. I would stress here that the most important thing to take away is that people care more about how they were treated than what the actual decision was. So be really careful. Mark touched upon that before, where you get only one chance to make a first impression. That's exactly what we're talking about here again when we talk about procedural justice. So if you're in court, next slide, please. Would you like a judge who looks at you like this? Or would you prefer a judge who looks at you like this? Our next slide. And this is a little girl whose adoption I did. She is obviously Justice Ginsburg, wanted to be warm and welcoming. So our next slide here. These are just a couple examples that we've pulled from courtrooms around the country. I think these come out of Milwaukee. On the left side, he says, please have a seat. Somebody's going to help you. So telling people that you are going to get help, just please be patient. On the right-hand side, it shows the location of where you are. It shows respect, and it shows signage, both in words and in signs, so that people who may not understand English can actually tell, okay, no camera, no food. That's obvious to them. And the last slide here, this is my perhaps all-time favorite out of Alaska. This is the court's pledge of fairness. And I realize you can't see this, but if you get the slide, you'll be able to read it. The important point is that the state of Alaska plasters these pledges of fairness next to every single courtroom in the state. And this is the state saying, this is our pledge of fairness to you, the public, telling them that you're going to be treated with respect, we're going to listen to you, and we're going to answer your questions. And it's in every single language, of which there are many, 50 at least in Alaska, and all the languages are included here. So I think this is incredibly powerful to show how important it is for the court telling the public, we care about you. So next slide, please.
And this is actually our final slide of our formal presentation. While it looks very basic, it's almost meant to be. This is our call to action. And in your registration questions, we had asked our attendees today who is currently taking part in a coordinated community response team. And the answer at the time they answered that question, greater than 60% of today's attendees not currently participating in that formalized. And so we had some discussion about that as presenters and with Dr. Websdale. And so it's not that we don't necessarily think that the discussions aren't being had with the fellow stakeholders in this process. There can certainly be improvement in where we're at with our CCRs. And this can also take really shape as other aspects, looking at your forms and your current process, looking even at your signage that Sue just covered with what's in the courtroom or what's in your advocacy center. Considering an anonymous walkthrough. This is a little bit more strategic with actually bringing someone through the court process. And I have to, before I forget, I have to say I am so appreciative of the chat comments that were made in today's presentation. It's rich in content. You guys are definitely the experts in your field, offering insight. I don't know, Ray, if we can make those available as well as the slides. I think there's some very relevant information in there. And then obviously considering focus groups. We're always in the position and the ability to do better, even if sometimes it is with less. So on my behalf, I want to thank you for your attendance today. I want to thank my co-presenter, Judge Susan Carbon. She's been a pleasure to work alongside. Ray behind the scenes with your IT expertise. And I want to thank you as attendants as well. We were originally scheduled this presentation for last month. My family was struck pretty hard by COVID. My wife and kids all suffered COVID at the same time. And fortunately, they've responded well medically. And so I just wish you all the best in your endeavors. Stay safe and stay healthy.
Of course, and thank you again, presenters. You guys did a wonderful job today. I know we are at time, but I do want to address a couple things. Like Mark said, we had a great chat conversation going back and forth with experts in the field, specifically talking about the law and some of the issues that they've encountered, specifically about how orders are not during the service part that the perpetrators or the abusers are very good at eluding. And that the addresses may not be showing up correctly. So that might be addressed later on, that we can talk about some of those, how we can address some of those issues too. There is a few questions, but I do want to ask that those participants that did ask those questions to email either Judge Sue Carbon or Mr. Mark Perkovich. The emails are stated here below. Again, thank you everyone for participating, using the polling questions. There is a survey, please use that. That does help us out. And then this webinar was recorded. We will be posting it on our NDFRI website, ndfri.org. Thank you again, and have a great rest of your day.